Hello, welcome. Hey, Billy.
Hi, Julie. How are you doing today?
I'm doing great. How are you?
Great, great. We missed last week. I was in Washington, D.C. visiting my brother for Easter. How was your Easter?
It was good. Yeah, it was nice. We kept the candy overload to a minimum,
Good for you.
so
Good
that
for
was
you.
great. And there was a nice event here in Sedona, and so we did that. And yeah, it was good. It was really good. How was your trip?
Great. I mean, it was kind of wet and gray and rainy, like very spring. And I was hoping to see the cherry blossoms, but they had already bloomed and then they were mostly gone. So that was a little bit of a bummer, but I got to hang out with my niece and it was a good time. So,
Believe it
yeah,
or not, we have cherry blossoms in Sedona.
you do.
Yeah, I didn't know that till I moved here, but there's white ones, there's pink ones, there's red ones. I mean, it's really amazing. And some of them have already bloomed and passed, but then there's some others that are still like very vibrant right now. But yeah,
That's
we
so
do have
cool.
that here.
That's so cool. I learned that the cherry blossoms in DC, which we originally got from Japan, don't bear fruit. Do you know if the Sedona ones bear fruit?
I believe they do bear fruit.
So cool. So
Yeah.
cool.
Because one of my son's friends the other day was reminiscing how he ate the cherries last year. So that's
Fun.
how I know that. But yeah, I haven't actually looked into that. So we'll see.
That's wonderful. Well, thank you all for joining us today. I'm Billy Tarasio, Arizona family law attorney, owner of Modern Law. This is Julie LeBenz, Arizona family law attorney, owner of LeBenz Law. And together we own Win Without Law School. And Win Without Law School is a platform and a program and a community that teaches people how to represent themselves in court.
Yeah, it does. And it's really unique because there's an interactive component. So it's not just like, here's a stack of forms, good luck. And, or here's watch one video and you're good to go. It's definitely more hands-on and helpful, which makes it a lot different than what you're going to get if you go to the courthouse for help, which they have really great resources, but there's a limit to the resources they have to offer.
It's like you can read blocks online, you can get forms online, but Win Without Law School helps people, I think, put it all together, develop a strategy, and determine how they're going to present their specific case. So it's a little customized and more, I think, holistic than the other resources out there. Part of what we do is every Thursday we do a live Q&A and a topic. Today's topic is going to be on moving from victimhood to empowerment. And specifically, we're going to be talking about spousal maintenance, whether or not you should get a job before you go through a divorce, or if that's going to hurt your spousal maintenance claim, when to do it, whether or not you should go back to school, all those questions that people have. But first, Julie, you want to
Yeah.
walk them through all the disclaimers?
Yeah, I'll get into the disclaimers. And there's one other part of the topic I want to add in, which is about creating a case strategy and how, in your divorce, you can empower yourself by figuring out what you want and starting to create a case to move that forward. It doesn't mean you're going to win on every issue, but that can really put you in a more empowered position than just being in like, oh, he or she wants this and what am I going to do and la la la, like where you're just at the whim of what the other side is requesting. You can really empower yourself by having a clear case strategy. So we'll talk about that too. And of course, a spousal maintenance case strategy can be part of that. But regarding today's talk, Billy and I do not become your lawyers by watching this video or by asking any questions. We will get to a Q&A for the last 30 minutes or so, 30 minutes of the call. And any information we give in the Q&A is just legal information. It's not legal advice. It's just general, oh, hey, this is what I think about, this particular thing, or you might want to explore this, but definitely getting one-on-one legal advice is very different. And that's what you'll need to do if you have a pressing legal need. And this is based on Arizona law. So we're licensed in Arizona, and we're going to be talking about Arizona family law.
I'm really glad that you brought up the strategy piece, especially with regards to the spousal maintenance topic, because I've been thinking a lot about this. I've read the draft guidelines. They're going into effect soon, and it certainly will and should impact your strategy when it comes to when and whether you get a job. Without a doubt, it should impact your strategy. So what my advice would have been, before these guidelines might be different than what they are under the guidelines. Why? Strategy. Everything boils down to strategy, just like you said.
Yeah. And tying your strategy into the law is where you have a really strong position.
Mm-hmm.
And that's something that we teach in Win Without Law School is we show you the law on custody, on divorce, on property, on modifications, on enforcement, on contempt, on all sorts of issues, and then help show you how to take your case and match it up with the law and then get it through the court system, which is complicated and convoluted, and there's all sorts of misconceptions about it. So we really help to cut through a lot of those misconceptions. And one of those misconceptions is, oh, I can't ask for what I really want because that's going to be deemed an unreasonable position. And it could be depending on what you want, but a lot of times it isn't. And a lot of people kind of curtail themselves, and that may be something that comes up with spousal maintenance as well. So yeah, everything is changing in regards to spousal maintenance in Arizona right now. We've had new guidelines so the law changed last year, and the change in the law said that now we have to apply these guidelines, but there were no guidelines created. So that was kind of a funny thing that happened, is we're supposed to follow guidelines that haven't yet been created, but now they've been created. They aren't yet finalized. And then it's also my understanding that there's going to be a calculator to go along with it, which is a huge change, because before there was no calculator. And now there's going to be this calculator. And so instead of just arguing the factors, now you're arguing factors within the calculator and these new guidelines. So yeah, the whole landscape has changed.
Yeah, it's a huge change. It's probably the biggest change in family law since the 2013 abolition of the word custody, I think. Like, this is going to have a massive change to us as practitioners, but also to people who are considering getting divorced. Because at least in Maricopa County, the spousal maintenance awards have been incredibly small and short in general. And under the guidelines, based on my read of the draft guidelines, that's not going to be the case. Well,
and they've also been so subject to disparity depending on what judge you're in front of. Several years ago, I went to a family law continuing legal education lecture, and there was this really creative presentation where they had a panel of judges, and then they did a series of fact patterns, and they had it all set up with technology. And so they put up the fact pattern, and then each judge got to put in, just based on those facts, what they think they would order for spousal maintenance, for the amount per month and the duration for how long it would be paid. And it was all over the board. I mean, it was probably 5 to 7 different judges, and it was all over the place. So really, your case outcome was so dependent on what judge heard your matter.
Absolutely. And whether or not you were likable, like there's just so much discretion. I do think that this is going to be a positive change, because it's going to provide us clarity, more uniformity, all of those things. I forgot to mention, when we were talking about Win Without Law School, right now, people can sign up and join for $1 for 14 days, which is very exciting.
Test it out, right?
Yes, you get to test it out. There's no risk to you. You can register, you can join, you can test it out for $1 for 14 days. So anybody who's listening here, or who is at YouTube or at Facebook, go to winwithoutlawschool.com and sign up today for $1.
Yeah, that's awesome. And then what happens at the end of those 2 weeks?
If you want to stay in, you'll go into our regular pricing, which is $150 a month for all access, or you can buy individual courses, which are $100 per course. But if you want all access, everything, the lives, the special Q&As, then it's $150 a month.
Yeah. And then this way, you don't have to be alone figuring out your case and all the ins and outs. And not only do we focus on how to prepare for court, but we also talk about negotiation skills and how to prepare to negotiate and how to create a strategy and all of that kind of stuff. So there's a lot of different elements to it.
So diving into our current topic, if somebody has been a stay-at-home mom, let's say they have an undergraduate degree in accounting. They worked in accounting for a few years, but then they stopped working to support their spouse's career. Their spouse, is, let's say, a nurse practitioner and makes $150,000 a year. Should the accountant spouse begin trying to find a job or wait?
Well, one of my initial questions is, how old are the kids? What's going on with the kids? Will that require childcare? If so, what's that going to cost versus what mom could earn? Are there any special needs children? Those are some initial questions I would have. What do you think, Billy?
Well, under the new draft guidelines, if you have not been working, and I want to pull them up because I don't have them memorized, there are a lot, but if you have not been working for the previous, I believe it's 24 months, then for this calculator and for these guideline purposes, you will not be attributed income. But the other interesting thing that the guidelines do is they separate between temporary spousal maintenance, which they say is for the purpose of, as much as possible, continuing the lifestyle you had during the marriage, which has never been said before, versus permanent maintenance, which starts under the calculator. So the duration is part of the guidelines, but the duration does not begin at the temporary award. It begins at the divorce. So that's interesting. These are all more information than we had before.
Yeah. And you mentioned attribution and that may or may not have set in for the listeners. So I just want to go into that a little bit. To me, that references child support, because in the child support calculator, a parent who is not working or a parent who is underemployed, who is working at a job that's less than what they actually have the skills and experience to earn. In the child support guidelines, the court can what we call attribute income to that parent. So if a parent's not working, but they're capable of it, the court can attribute minimum wage to them in the calculator. And so what Billy's saying is, under these new guidelines in the spousal maintenance calculator, a stay-at-home parent would not be attributed minimum wage, whereas in the child support calculator, they would be. Theoretically, depending on the circumstances. But yeah, that is a big difference between those calculators.
Yeah, big difference. So I might say, wait, I might say that you don't need to necessarily rush off to find employment as soon as possible. If there is enough money, and if we run this calculator when it becomes available, and we can lock in a temporary maintenance award for you, we might want to wait. And because your life is in such an upheaval right now, nobody's sure where they're going to live, what the parenting plan is going to look like. Some people have absolutely no choice but to go get a job immediately. And other people really benefit from taking a little bit of time to settle before they try to introduce a new job in addition to everything else that's new.
There can also be a benefit in gathering the evidence. So you may want to go looking for jobs just to see what pay range you're qualifying for, or maybe that no jobs are available to you if that's your position. It's one thing to just say it, but it's another thing to have some evidence to back up your position. So there could be just an evidence gathering expedition in applying for some jobs or seeing what your options are or aren't.
Right? Talking to a recruiter, you want to get information so you can make the best decision. Let's say instead we run the numbers in the calculator, we see how much you might be eligible for in a temporary amount, and you can make much more on your own. That may be the better choice.
Right. Start building those job skills, start, potentially moving your way up to make more money.
Because ultimately, this topic is about moving from victimhood to empowerment. And empowerment is best achieved when you can provide for yourself, without a doubt. Because I can't tell you how many clients I've had who've been awarded spousal maintenance and not collected it.
Yeah, the collecting part can be a big challenge. I mean, it can't be flushed in a bankruptcy, so that's good. And there are various collection mechanisms, but there's certain people where, yeah, it's very difficult to collect. So I agree with you. If you don't need to depend on somebody else for a monthly payment, that's ideal.
That's empowerment. That's ideal. And if you're thinking about getting divorced down the road and you're wondering, should I be developing my career skills and my income now? Or is it better off for me to wait because I'm going to get more in maintenance? I'm going to tell you my personal opinion, without meeting you, without talking to you, is get a job, develop your career, develop your own earning ability, because that is always a better option. You can count on yourself. If somebody doesn't want to pay you, they can change jobs. They can refuse to pay you. Then you have to go to court for an enforcement action, which takes more money and more time. And that's all time and money that you're not using developing your own skills, your own earning capacity. It's more dependence. So when in doubt, please, please develop your career, develop your skills.
Now, these same issues can come up in a custody case. So, of course, in a divorce, spousal maintenance is going to apply potentially. In a custody case, though, you're not going to get the spousal maintenance, but you could still be facing a lot of these same issues. Maybe you were living in one household. Now you're going into two. Maybe you were the stay-at-home parent. Now you need to go out and get a job. And so there, a lot of these same issues can come up, not necessarily in the spousal maintenance context, but as far as, okay, what income should be used in the child support calculator? Should there be a child care credit? What's the cost of child care? If I go work and I need to put my child in daycare, what's that going to cost versus my earnings? All of those are factors in the child support calculator as well.
Absolutely. It's a great point. Usually people in the child support calculator aren't going to be getting enough to live on. That's usually the case with spousal maintenance as well. The other really interesting thing about these guidelines is that it makes clear what is income and what isn't income in that spousal maintenance calculator, with regards to property division. So let's say that you're getting bought out of a business or some other type of community property and somebody's making payments to you. That does not count as income when determining spousal maintenance. That does not count as assets, because factor one is, do you have enough property to support yourself? And the guidelines define property to support yourself does not mean you're using the property to support yourself. It means that the property can create income for you in terms of investments or dividends.
Yeah. And there was a case on that too, about how, real estate's one thing. The question is it income producing real estate or not?
Right. And even though there was a case on it, I still saw judges and lawyers argue, hey, they're getting $250,000. Why would they need spousal maintenance? But that's not the analysis.
Yeah. So yeah, spousal maintenance is a really difficult issue. Ideally, these guidelines and calculator make it a bit simpler, because we've been in this very nebulous place where we're just arguing factors and picking out numbers. Right. And so hopefully this will make it clearer. But just like with the child support calculator, there's going to be knowledge you need to use the spousal maintenance calculator correctly. Because, and I haven't even seen this calculator yet, but I'm guessing that that's how it's going to be, because with the child support calculator, it's definitely like that. I see so many self-represented parties that use it incorrectly. Because you need to know the guidelines, and then you also need to understand the form, and there's a ton of strategy that can go into it. And we share a lot of insider tips on those types of strategies in Win Without Law School. But, we'll see what happens with this calculator as it comes out. I hope it does simplify spousal maintenance, because it has been a really challenging issue up until this point. But I think your initial point is valid. You know, there is going to be strategy around this, you know, starting your new life post divorce or post, you know, just non-married relationship. And how do you navigate that and tie that into your case strategy? And I think overall, a lot of it is doing what's best for you in the circumstances. You know, sometimes you just got to do what's best versus analyzing every part of your case. But
Right.
you know, either way, if children are involved, there's always going to be this issue of how are you juggling work with childcare and child responsibilities.
Absolutely. Absolutely. We do have a lot of questions here we can start getting to, unless you have anything else on this topic.
Yeah, just to finish out on the point about a case strategy. So, you know, a lot of people go into the divorce or the custody case and feel like the other side is in complete control. And it brings on a lot of worry and stress, like, oh, what am I going to do? And they're going to get what they want. And there can be this very victimhood mentality going into the case, and it can bring on a lot of fear. And so one way to start shifting that is to start to figure out, what do you want?
Mm-hmm.
And, you know, then you can start to see, where are you in agreement? And then where are the points of contention? And then, you know, start to put more time and effort and resources into those points of contention. But that can also just give you some grounding and also give you some confidence, because now you have points to talk about, you have points to negotiate around, instead of just feeling like you're at the whim of whatever the other side wants.
I agree. And I think there is so much fear and anxiety surrounding divorce. It's almost impossible to get away from that. And yet, if you are able to look at your divorce and your future with optimism, realistic optimism, I think I can make X amount of money. An optimistic, I think I can have X relationship with my spouse. If you pick an optimistic goal that is also realistic and you move towards it, you're going to make better decisions in your divorce to end your divorce more quickly, more simply, with less conflict, so that you can get on to building your future with optimism. Now, I know that's easier said than done, but when I see people do that, they have happier futures. They don't come see me. When they do come see me, it's just to say hi. It's to message me on social media about how good they're doing. It's not, you know, coming back for modification after modification.
Yeah, definitely. All right, let's jump into some questions.
Okay. If my divorce is finalized, can I take my former spouse back to court with the new laws?
It sounds like she's talking about spousal maintenance. So maybe.
Let me look it up. Modifications on page 20. I have it in front of me. I'll go down to page 20.
I mean, first question is, was spousal maintenance ordered?
Right.
Because if it wasn't ordered, then you likely can't go back, because generally that's a final finding that there is no spousal maintenance ever. And then if there was spousal maintenance ordered, was it modifiable? Because if you agreed to non-modifiability, then I don't see how you could go back. So,
right.
So you have spousal maintenance, it is modifiable. And then the next question, I guess, would be are these new changes in the law justification to modify? Does that amount to a substantial and continuing change in circumstances?
Yeah. And I think on its face, no. I think you still have to meet, it doesn't say in the guidelines, but I think you still have to meet the legal burden to modify, which is everything you just said. It must be modifiable. There is no way, and I've looked at this extensively, there's no way to get around a non-modifiable order. Even if it's unconscionable, you cannot get around it. So if it's modifiable and you have other substantial and continuing changes of circumstance, then you can request a modification.
And once this calculator comes out, let's say you run the calculator and you run it accurately, and it shows a 15% change in what the current spousal maintenance order is, I wonder if that would amount to substantial and continuing change in circumstances, because that qualifies for child support.
It sure might. I'll tell you, we have a case right now where we're asking for modification of spousal maintenance. these people were married for a long time. Dad was a pilot. Mom got like 3 years, and she was a stay-at-home mom. It was like a 30-year marriage. It was a, there was, like we talked about, there's a wide variety of awards, but it seemed very low. We're arguing substantial change in circumstance on different things than the guidelines, but we're very hopeful that the guideline number will help
Justify.
justify or move the needle for her. So we'll see if it works. Okay, next question. What about third-party rights when they're not using the time?
Well, that potentially could be grounds to modify the award of third-party rights time. So award the visit or modify the visitation time because they're not following the order. But, it's real fact intensive. Like, did they just not exercise their time once or twice because somebody was sick or there was a conflict? Like, was there a justifiable reason why they didn't do it? Or are they just or are they just not doing it because they don't want to? It's just, in my experience, people usually fight pretty hard for those third-party visitation rights. So it makes me question why they're not exercising it, and if it's a valid reason, because somebody's ill or, whatever, some sort of conflict, or have they just decided they don't want to exercise visitation anymore? But document the times they aren't exercising it, and it needs to be more than a couple of times. It would need to be consistent, I'd say, for a few months. But yeah, and sometimes the third-party rights are infrequent. Sometimes it's just once every few months or one weekend a month. Like that, it's usually not an extensive amount of visitation time. So documenting the missed times, it may be few and far between. So yeah, there's a lot to consider here.
The judge let my ex use daycare during his time when he works. The contract is between him and the provider. Can I get the daycare logs?
I would think so, under that access to records provision, that both parents are entitled to records related to the child. So you could go to the provider, and if they said no, cite to that law. And then if they still said no, you could potentially ask your co-parent to produce those records, because there is a provision in there that says that either the provider needs to produce them or your co-parent needs to produce them upon reasonable request.
Very good. Is it too much for me to ask for the house, child support, and spousal maintenance? I've been married for 25 years. The kids are 18 and 16. I love this question.
I don't think it's too much to ask, but just realize, there's likely going to be a give and take. So if you get the house, what happens to your spouse's interest in the house? Is that just forfeited, or is there a credit somewhere else? Or does the house get sold years later when the kids are older? Like, what is the give and take? And so what was it? The house, child support,
spousal maintenance.
And spousal maintenance. Child support, that's pretty standard. That's going to come up in any case, at least an analysis to determine the amount. And then spousal maintenance, I would look at the factors, look at 25319A, factors 1 through 5, and see if you have arguments to show you qualify. A1 is about having sufficient resources to meet your reasonable needs. And that might be a claim if, you're a stay-at-home mom or something like that. What do you think, Billy?
I think these are three separate issues and we shouldn't conflate them. And you have legal grounds and legal standing that must be analyzed under each of these sections. So the house is an issue of property division, which we talk about, and there is a way that is divided, that you are legally entitled to have property divided in a certain way. That has no impact, should have no impact on child support or spousal maintenance. And what I like so much about the spousal maintenance guidelines is it really helps separate the issues. Child support should be analyzed as child support. Spousal maintenance does impact child support because income that is awarded as spousal support comes off of the income of the payor and onto your side of the child support calculator. So no, it's not too much to ask for. I don't think. You just have to analyze them separately.
And one other point about the house is I'm assuming the house is subject to a mortgage in both husband and wife's names. And so if wife is going to get the house, then does wife qualify to refinance the mortgage in her name alone? Or is husband willing to stay as a co-borrower on this mortgage post-divorce? So it's easy to be like, I want the house. And of course, there's all those reasons why, but then there are also some technicalities to consider about compensating the other spouse for their financial interest in the house.
Right.
And then also what happens with a joint mortgage, and any other debts recorded against the house.
Yes.
There's definitely some complicated issues to iron out. And I highly recommend getting legal advice for anything involving real estate, because you can really mess things up.
Yeah. And with interest rates the way they are, it's making it really hard, because many people have a mortgage at 2% and a house payment that's like $1,400. And in order to buy out your spouse, you would have to refinance that to take the equity out to pay them. And then you're at a higher rate and then the payment goes up. It's complicated. So I agree with you. Like this is a real complicated issue that you should take the time to think through and think about all these different options. You may want to talk to a lawyer about it.
And one final point, Billy, is you also need to consider the finances of your spouse.
There's only so much money to give.
There's one thing to be like, I want the house and I want special maintenance and I want child support. And yes, you may have really compelling arguments for all of those, and the law may support you in all of those, but then there's also the reality of how much money is there to be paid to you.
Right.
And that's where these calculators are going to come in, and then these other considerations about the house as well.
And you can trade, you can trade. So just because you might analyze the law and the law says X, but that's not what you want. You want something very different and you want to package up a creative solution. You can do that if you're not asking a judge to do it. If a judge does it, then it's appealable. So, okay. I'm on a first-time alimony request where the question was silent in divorce, brought up for the first time 4 years later. What salary did you determine it on? The current salary or the salary at the time of divorce?
I'm confused.
You can't. The answer is you can't. If you get divorced and you don't have a spousal maintenance award, you cannot go back 4 years later and bring it up for the first time. Even if it wasn't mentioned, even if you didn't think about it at the time, you cannot.
I mean, unless her decree has been reopened, where you're starting anew, which is really hard to accomplish, unless you're there, then there's no going back in time.
You're absolutely right. Yeah, that's true. If you set aside your entire divorce decree and you're now married up until this moment and you're starting over, then you can ask, but otherwise you can't.
And even with that, I don't know if you would go back in time. You'd probably just start from now, because I don't know what, I don't know, but
yeah.
But yeah, you're not going to be able to just bring that up years later if your decree is final.
Right. Let's see. Do step parents' income count towards child support?
No.
Same-sex marriage. I am married to a woman and we had a child by a donor. If we divorced, what rights does she have?
Oh, this stuff is so complicated.
I love these questions. You guys are so smart.
Yeah. What are your thoughts on this? I know there's been some case law on this.
All right. So if you're married, I think the presumption of paternity and maternity applies. I think if you're married, then there's donor. If there's no dad on the birth certificate and you're married, I think that there are maternity rights. But please talk to a lawyer so that we can research this. But I'm fairly confident and I would have to look, but I'm fairly confident that that's the law and there would be rights. And let's say that I think that's what the law is now. And beforehand it wasn't, but even under these circumstances, mom A and mom B, who didn't biologically birth the child, would still have a third party rights claim. And an in loco parentis claim. She acted as a parent. She was the parent. She would still have a claim, a custodial claim, and I don't know if we'd call it parenting time. That depends. But I'm fairly confident today, under the law in Arizona today, 2 moms and 2 dads have rights. If you're married, they go into play as soon as you have a child.
And then the other question is, are you facing a contested or an uncontested situation? Because if it's uncontested and you can, and what I mean by uncontested is both people want to sit down and negotiate and reach an agreement. It doesn't mean that at this stage you agree to everything, but you are in agreement to try to resolve it between yourselves and not go to trial. If you're there, then reach an agreement. You can figure out this stuff. It's really if you're getting resistance and the other side is like, you have no rights or you don't get this and that, where you're going to need to really dive into these legal issues and really any agreement you're going to reach, definitely have a lawyer review that before you sign it, or work with a lawyer, to negotiate the agreement. But a lot of these sticky legal issues can really come up if there's a contest. If the other side is saying, no, you have no rights, you can't see the child, all of that, it's a totally different situation than if you're like, okay, yeah, let's share parenting time and let's figure out a schedule. And I acknowledge you're a co-parent and all of that.
Right. How often does a judge take into consideration kids who are 16 and 14, their opinion on where they want to live?
The older the children get, the more relevant their opinion is. And so I really think it's a matter of how are you getting this information in front of the judge? How is the judge? Because so many people just think the judge knows everything, but the judge only knows what you provide the judge with.
Mm-hmm.
And so are you putting this in your pleadings about what the kids want? Are you requesting an in-camera interview and the judge is actually talking to the kids? They're not going to testify at your trial. So I think your bigger question is, how are you really getting their position out? Is there a parenting coordinator who's interviewing them? What is happening with that? And how is their opinion getting to the judge? And then, the older they get, the more significant their position is.
Yeah. And it also matters, I think, are you getting a divorce or are you asking for modification? Mm-hmm. If you're asking for a modification and you're coming from a place where, let's say you shared equal parenting time and the kids are saying, this is not working for me, I feel like that's a different presentation than my parents are going through a divorce and we hate dad because he cheated. just as hypothetical, or mom left, I don't want to see her ever again. Like that is going to be a different analysis for a judge.
Yeah, that's a good point.
Do I need to notify the other party's attorney before I submit a motion for trial, or after I file the motion for trial?
So that would be a motion to set and certificate of readiness. And there's specific points that need to be in that motion. So if you use the court form, it does have those points in it. If you're making up your own form, you're going to want to make sure it complies with the rule to set a trial. But you file it and then you need to provide the other side with a copy. You need to serve a copy on the other side, usually by regular mail. If you've agreed to email, you could do that, or could do email and mail.
Most of the time when we file any motion, we need to, or it's preferred if we cite the other side's position within the motion on any motion. If you can do it, I'd say it cannot hurt you. And this person's kind of saying, what should I do? This or this? So I would say ask probably, but you can, it's up to you. So next question. My ex-husband wants his girlfriend to be able to be a caregiver during his absence. The guidelines say that he should offer me the extra parenting time, but he doesn't. Is that enough to file for contempt, or would that look frivolous?
So the guidelines are not going to be sufficient for a contempt citation, because contempt requires you to show there's a court order with terms that the other side had notice of and then willfully violated. So you're not going to be able to just cite to the guidelines and then say they're in contempt for violating a court order. In many parenting plans, there's terms about right of first refusal. So you could look through your plan and see if that's in there. And then that could potentially be something to push forward. There's another angle too, if the girlfriend's constantly with the kids, is that grounds to modify if it's time that you want, and this is happening consistently and you could accommodate that time, then maybe there's a modification request.
Right.
But, I'd be curious, how much time is it? What are the actual blocks of time? How often is this happening? Do the kids like her or not?
And have you asked dad? All the things. If you have children, can you forego child support in favor of alimony only?
I mean, there may be ways to work a deviation to do that, but it really just, it depends on a lot of different factors. So that's a hard question to ask. I wouldn't necessarily put it in those terms, but you could potentially have a zero child support obligation if there's, equal parenting time and essentially equal gross incomes. You can potentially deviate down to zero depending on the circumstances, and then, still do spousal maintenance. But I wouldn't necessarily put those together as, negotiating away child support so you get more spousal maintenance. That might be a hard sell for a judge because that doesn't really match up with the laws.
Yeah, and I'd also like to know why.
Right.
Like what
Yeah,
are we really trying to accomplish? Because the dollars are the same. So I would like to understand a little bit more about why. If the holidays are split with my ex 50-50, sorry, let me read it again. If I split holidays with my ex 50-50, is spring break considered a holiday or a break?
Spring break is a break. Yeah. Holidays are Christmas, Thanksgiving, 4th of July, Easter, things like that. And then breaks are fall break, winter break, spring break, summer break.
Right. If my 17-year-old and father change the parenting plan before the court without my consent, do I have to pay arrears? All right. So here's what I think you're saying.
Yeah. Okay.
I think that dad and the child didn't do anything. If dad got a default order to change the parenting plan and you didn't show up, and now you owe child support, can you argue against having to pay the child support because you didn't show up or didn't know about the change? I think.
I mean, it really depends on what the facts are around that. Most likely, no, if you had sufficient notice, which if the court went forward, the court had a belief that you had sufficient notice. So yeah, you might be stuck with that. You can potentially get it reduced if you can get dad to agree. You can do an affidavit with dad to either reduce it or cancel it out. But that's your best and easiest path, is to get dad to agree. But of course, that may not be easy. But yeah, undoing a court order is tough.
It is. It is tough. Can I file a modification on my own?
You can, yeah. You can. The question is, do you have a case strategy? Do you know the procedure? Do you know the standards? What's your plan to try to negotiate? What's your plan to prepare for trial? So yeah, you can. And we teach all of that in Win Without Law School. So if you're considering that, you might want to try out the $1 offer and see what you think.
Join Win Without Law School. It's $1. Do it. All right. Mom moved to Jamaica without telling the court. Can I have her served out of the country?
You can. It's often more difficult. Like I've had some cases where service in Mexico has come up, and there's many ins and outs to it. There's supposed to be this whole Hague Convention thing, which can take forever, but then we've also just done service, and then the other side is participate in the case, and then we've just gone forward with that. So there's a lot of ins and outs with it, but yeah, potentially. I've never tried service in Jamaica, so I don't have any insights on that.
Yes, this may be a Hague issue. I highly recommend you talk to a lawyer. You also can reach out to the police or the FBI and see if they will help you if it is a Hague issue. And we don't have a ton of time. We only have 3 more minutes, so good luck. Next question. Dad was deported. Can mom get full custody?
Sure. Yeah, I don't see why not.
Kind of have full custody.
Yeah.
Right? If dad's deported, the only reason you might need a piece of paper that says you have full custody is that I can think of at this moment is that you want a passport. And in order to get a passport, you have to have sole custody, sole legal decision-making, or a signature. But other than that, you have it.
Or you think he's going to come back.
Right. Or you think he's going to come back. Do I have to file a notice of issues within a pretrial statement?
And if you're married too, it could be good to end your marital community if dad's been deported. Just
could be. Yes.
Yeah. You might not want to.
Probably not helping you much.
Like if you have a retirement account you're contributing to, or you have a house and you're paying down the mortgage, or you intend to buy a house, or get other assets or debts, you likely want to end the marriage to move on with your life. One more.
What happens at an RMC if the other party never responded to the petition to modify?
Well, so this is under Rule 91. A response is optional. Right. So they're not required to respond. But if they don't respond, I think it's 3 business days before the RMC, then they're not allowed to respond thereafter. So they lose the right to do a response, I believe, but it's not required. So nothing should happen.
So your RMC will move forward as normal. So thank you all for being here. I believe that we are here next week as well. So we'll be back a week from now. Sign up for Win Without Law School. Go do it today, $1. And we will see everyone next week.
All right. Thanks, Billy.
Bye.
Bye.